than someone who's worried you'll tell people the truth. Nobody is more focused on trashing your name than someone who's worried you'll tell people the truth. Nobody is more focused on trashing your name than someone who's worried you'll tell people the truth.
They wanted me to spit reality rap.
What the problem is? What the problem is?
Whatever that fucking mean. Yeah.
Let's go.
Fuck you niggas and I mean that. You want war, bitch, I bring that. Real niggas dressing all black. I'll put your life in the past. All you lames ain't gon' last. Put that dumb shit in the trash. I be y'all out in the jungle wildin' with gorillas even when it's fast. I was boosting them was back up. Run all up in your stash house. Tell you niggas kick the cash out. 45 on your ass. A lot of y'all dudes is acting. Keep on saying that y'all trapping. Put you right up on the news channel 45 asking what happened. Big nigga and I'm hustling. I dare you niggas try to touch me. It's so official like the ref. I got some real niggas that'll leave you dusty. I ain't never had nothing. Making something out of nothing. Out here grinding real hard trying to turn the Debbie to an English muffin. I went to work like a slave nigga. Streets know I'm a go-getter. I can never be a whole nigga. Real facts, you's a whole nigga. Catch the boy in the cup. Watch the pot bubble up. Profit going double up. Really never gave a fuck. My whole hood really bout that. Cross the line, then we off black. Kill a nigga when it's off black. Smoke you chumps like some gas. My father never really fuck with me. None of these niggas can't fuck with me. Say it twice so you remember me. None of y'all can't fuck with me. So high off life like I just caught the molly. Wait for a young dumbass nigga to try me. Giving them shots to the face of the body. Guns like a boxer, man, shots to the body. I done did a lot of dumb shit. A lot of beat a hater up type shit. I got that shit straight from high. Not a nigga out real. I saw the teens of that musty. It was loud, it was crunchy. That's when housing came and rushed me. That's when housing came and rushed me. Came around every corner, had me on the ground. That's when they cuffed me. Had to switch the game up. Started capping up for slugs. I'm getting money, nigga, what? I'm getting money, nigga, what? Nobody couldn't tell me nothing cause a real nigga never gave a fuck. Homie told her that was fucked up. Real talk, that was fucked up. When I see you low, nigga, hit you with that 40, let you know your time's up. Gritty nigga still hungry. Yes, the boy still hungry. I be in my own lane, fighting like a champ, getting to the money. All that stupid shit, ain't gonna give me some money and ball out. I'ma stack it so high to the ceiling that when it come to my house, you gon' fall out. Only real niggas know what I'm talking about. Shoot up a nigga like filming a movie. Spit it for reals like we shooting a Uzi. Crossing the beach, you be out of here. Only you know I don't show no fear. Treat you like magic, you disappear. Make sure you haters is crystal clear. Get them away from here. Get them out of here. Get them out of here.
There you go, there you go. Dress it up to make it real for me. Whatever that fucking means.
4 nights of torment drowned in their screams. 5th night's here to shatter their dreams. May 5th trial dawns, jury's cold gaze. For the kids he broke, will set hell ablaze. 5 nights at Diddy's where innocents died. God's wrath roars, let the guilty be tried. Feds tear the veil, sex trafficking laid bare. Empire of evil, a devil's cruel lair. Talia's voice breaks, drugged in 2001's night. Raped by Diddy and God, her soul lost the fight. 5 nights at Diddy's, this is part 5. Diddy is scum and should not be alive. Sentence them to death, pray victims survive. For those that didn't make it, children long gone, we pray you found peace, call heaven home. Hollywood's damn souls will burn. 5 nights at Diddy's, justice we earn. LaTroya won a contest, thought she'd live the dream. 2006 party turned to a nightmare scream. Drugged till she faded, assaulted in the haze. Woke in a hospital, lost in a trauma maze. 5 nights at Diddy's, this is part 5. Diddy is scum and should not be alive. Sentence them to death. we earn. A 13-year-old girl post-VMA glow, drugged with the red drink, raped in the show. Ashley's 2018 fight, rape while they filmed her cries. Escaped with a knife, but her spirit still dies. This is part 5. Diddy is scum and should not be alive. Sentence them to death, pray victims survive. For those that didn't make it, children long gone, we pray you found peace, call heaven home. Hollywood's damn souls will burn. 5 nights at Diddy's, justice we earn. God's on his throne, sword dipped in flame. Every mogul, every suit, scream out their shame. A 9-year-old boy, bad boy auditions door. Abused by Diddy's childhood no more. Ooh. Liza at 16, 1990s dark stain, drug forced by Diddy, choked through the pain. Victims raped till they broke, IV drips in their veins, revived to be tortured in Diddy's cruel charge. 5 nights at Diddy.
The thing that I see, the thing that I have, I can feel the pain inside, oh inside. The shoes that I feel, the scars that me grow. As solid as I am, I'll never fall. Would you see me? I seen in me. A long time ago, I never fall. I stood 10 toes. Oh, yeah. 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 The things that I see, the things that I have, I can feel the pain inside, oh inside. The shoes that I feel, the scars that me grow. As solid as I am, I'll never fall. Would you see me? I seen in me. A long time ago, I never fall. I stood 10 toes. The things that I see, the things that I have, I can feel the pain inside, oh inside. The shoes that I feel, the scars that me grow. As solid as I am, I'll never fall. Would you see me? I seen in me. A long time ago, I never fall. I stood 10 toes.
Gentlemen, may I have your attention, please? The show starts in 10, 9, 8, 7, 6, 5, 4, 3, 2, 1, go.
Whatever you want, whoa, whatever you need, my heart belongs to you. Oh, whatever you need,
you want. Oh, my heart belongs to you. I say whatever you need. Whatever you need. My heart belongs to you. Whatever you need. There's nothing I won't do. Whatever you want, my heart belongs to you. I say whatever you need.
What up, what up, what up, what up? You know, we got a paperwork party today. I'm sending these last joints out. We got a paperwork party. And we back on the saddle. We doing our thing. Hold on. Check, check. Oh, yeah. Oh, yeah. Loud and clear. We back on the saddle. And we about to jump in this paperwork party for Diddy. But the thumbnail that's up there is not the thumbnail that I wanted to use. Oh, man, I ain't like that. I did not like that. The thumbnail that's up there is not the thumbnail that I wanted to use. So that sends me to a place where I had to ask everybody. First of all, shout out to everybody that's here. I hate this because I got to send all this stuff out. I'm just sending it. Boom, boom, boom. Knocking it out. All right, cool. All right. So I have to ask the question. Do y'all believe that Diddy is innocent or do you believe that he's guilty? Let's start there. Shout out to everybody that's here. Sky Life in the building. What's up, Sky? D Johnson, what's up? Miss Lady T Caramel, Stephanie Willie. What's going on? Do you believe that Diddy is guilty or do you believe that he's innocent? Because we're going to do this paperwork party together, y'all. We're going to do this paperwork party together. Let's see where I'm at. Let's see. Nothing. Let's see. Okay, cool. Get it out of the way. Cool. Okay. Yeah. First of all, we're gonna start and we're gonna clean up this rumor, okay? The rumor that we're gonna clear up is that they say R. Kelly's a pedophile. Let's clear this room up real quick. And the way we clean it up is with facts and with truth, right? So with that being said, boom. I'm gonna give y'all the paperwork. I'm gonna hit it on your head with it. I'm gonna open it up. This is the judge talking. And the judge said this was not prepubescent sex child porn, which is a particular type. And there is, as I understand it, based upon Dr. Dietz' report, that Mr. Kelly is not a pedophile. I'm going to read that again. What up, Prima? I'm going to read that again. This was not prepubescent sex child porn, which is a particular type. And there is, as I understand it, based upon Dr. Dietz' report, that Mr. Kelly is not a pedophile. Watch this. But again, these tapes got out there. And that's the nature and circumstances of the offense. Why did I read that? Because of what comes behind it. And what comes behind it is, and it's horrendous. And everybody agrees with that. And it's deserving of very, very serious consequences to Mr. Kelly. Now, the history and characteristics that both sides have gone into. Ms. Bonjean points out that he had a fatherless childhood and he was raised in poverty, alcoholism in the family. He was subject to what has been a nice euphorism, adverse childhood experiences, another word for sex abuse. He is marginally illiterate. He has a learning disability. I'm going to stop right there. And the reason why I'm going to stop right there is because if those were the key factors for R. Kelly getting a consecutive sentence, don't you think those will be the same factors of Diddy getting a consecutive sentence? What I'm saying is Diddy is not illiterate. Diddy is very smart. Hey, picture printing for myself. With that being said, Diddy will have to do time for the Cassie video alone. Skylife said innocent. Skylife said she believed Diddy is innocent. Willie said he's guilty. See, and you have a difference of opinion. Skylife said that she believed he's innocent. Well, Skylife, unless you've been hiding under a rock after being at trial, is proven that he's not innocent. What people don't understand is you only got to prove 2 points of the RICO. And I'm going to open the phone lines later on as soon as I read this paperwork. You only got to prove 2 points of the RICO. 2 points of the RICO. And if you only got to prove 2 points, and the government has already proven 8, everything else is overkill. So I think the government should rest their case because they already proven 8 of the RICO. They already knocked that out. But what you see on the screen is something crazy. And the reason why I say crazy is because, let's go here. I got to get to it. It's because the press, not the people that got press passes, because if you want to know the truth about them press passes, that's just something just to look good in if you're not real press. I'm just being honest. Well, it's a letter that's been put out. Is this the one that I'm reading? When did that come out? Yeah, it's the one I'm reading. Yep. A letter has been put out. And Ms. Doe, as to Sean Combs' address to Judge Aaron Samarian from Lindsay A. Lewis, dated 6/5/25, opposing the June the 4th, 2025 letter on behalf of a collection of news organizations requesting that the government change their order of its witnesses. Wait a minute, what? Since when? See, this is what I mean. Since when do the press have power to tell the government what to do? But on behalf of a collection of news agents or organizations, on behalf of a collection of news organizations requesting that the government change the order of its witnesses or otherwise delay Jane's testimony to allow for a pre-redaction of exhibits to be introduced during Jane's testimony. Document filed by Ms. Doe. Ooh. Whoa. So let's read. The Honorable Aaron Sumerian, United States District Court. We got the government that's responding back. Dear Judge Sumerian, this letter is submitted on behalf of my client, who has been granted the right to proceed at the above captioned trial under the pseudonym Jane, who I will not say who it is, because I'm not trying to go to jail. I'm not trying to sit back and have to be questioned by them folks, and opposes the June the 5th, 2025 letter on behalf of a collection of news organizations requesting that the government change the order of its witnesses or otherwise delay Jane's testimony to allow for a pre-redaction of exhibits to be introduced during Jane's testimony, as set forth in detail below. The news organization's First Amendment and common law rights to trial access, and namely to trial exhibits, will not be infringed by the government's rolling release of correctly redacted evidence to the public, particularly given that the contents of the exhibits at issue will nonetheless be conveyed to the press and public in the courtroom in real time through the witness testimony, and will be provided to the press and public as soon as is practicable. Nor do they pose a reasonable alternative to allow Jane's testimony to proceed as planned. Accordingly, the news organization's requests should be denied. The news organization's First Amendment right to access trial is not infringed by non-contemporaneous release of evidence to the public. Okay, while it is well established that there is a qualified First Amendment right of access to criminal trials, Globe newspaper case law, the right is qualified because it may give way in certain cases to other rights of interest, such as the defendant's right to a fair trial or the government's interest in inhibiting disclosure of sensitive information. Waller versus Georgia case law. Then you have, under the First Amendment, the court should consider whether the measures restricting the public's access to the trial are essential to preserve higher values and are narrowly tailored to serve that interest. Case law. To that end, although the First Amendment requires that citizens know what has transpired in a courtroom, it does not require that they receive the information in the most dramatic form. In response to NBC Universal case law. The higher value standard articulated in Press Enterprise 1 amplifies the privacy rights of vulnerable individuals, and that the privacy interests of those who resist disclosure, here, Jane, have been identified as such a higher value, Doe 1 versus J.P. Morgan case law. Also stating that the privacy interests of innocent third parties should weigh heavily in the court's balancing equation. Certainly, given the fact that Jane has been granted the right to testify under a pseudonym in order to avoid particularized and unique challenges that the defense and prosecution agree she would face if her identity were revealed, and which premature publication of exhibits in connection with her testimony might result in her privacy rights more than justify delayed disclosure. See docket number 266. Moreover, the news organizations rely on Hartford Current Company, LLC, versus Curl, which, while on point regarding the First Amendment balancing test itself, addressed a wholly distinct issue, finding that a blanket prohibition on access contravene the presumption of access. Hartford Current Company, LLC versus Curl case law. In that case, at issue was a Connecticut state law requiring the automatic sealing of all judicial records and the closure to the public of all court proceedings, in cases transferred from the juvenile docket to the regular criminal docket. Harvard current case law. They also focused on automatic and mandatory nature of the ban and decided that the First Amendment requires simply presumption of openness that can be reviewed on a case-by-case basis. Here, the government is compelling interest in carefully and properly redacting the exhibits that it releases to the public and press. This interest is further heightened due to the recent inadvertent exposure of another pseudonym witnesses, personally identifiable information by way of evidence published to the public. And the redactions themselves are narrowly tailored to remove only that information which would identify the pseudonym's witness. This is therefore quite different from Harford Current Company, LLC, case law, where the records were to be sealed, not simply released in a redacted version on a rolling basis, when such release would not risk revelation of sensitive information. The news organization's common law right to access trial is also not infringed by non-contemporaneous release of evidence to the public. The common law also affords the public a right to access evidence introduced at trials, but it is not absolute. Okay? That's the case law of Nixon versus Warmer. Applying the common law right of access consists of a three-step analysis, the United States versus Amidio case law. First, the court must determine whether the materials at issue are judicial documents. 2, the court must determine the weight of the presumption by assessing the role of the material at issue and exercising its Article 3 power. And third, the court must balance the competing considerations against disclosure by analyzing the countervailing factors, which include but are not limited to the danger of impairing law enforcement or judiciary efficiency, and the privacy of interest of those resisting disclosure. Dugash versus Pyramid case law. Where testimony or documents play only a neglectable role in the performance of Article 3 duties, the weight of the presumption is low and amounts to little more than a prediction of public access absent a countervailing reason, Amidio case law. Pursuant to the common law framework, in determining the weight to be accorded an assertion of a right of privacy, courts should first consider the degree to which the subject matter is traditionally considered private rather than public. The nature and degree of injury must also be weighed. This will entail consideration of the sensitivity of the information and the subject, Amidio case law. Courts, however, have long declined to allow public access simply to cater to a morbid craving for that which is sensational and impure. Caswell case law. So, the law offices of Draketail and Lewis submits the news organization cite an application of National Broad Company Incorporated to support their argument for contemporaneous right to access. June the 4th, 2025, letter at 2, application of National Broad Company held, however, that when physical evidence is in the form that permits inspection and copying without any significant risk of impairing the integrity of the evidence, or interfering with the orderly conduct of the trial. Only the most compelling circumstances should prevent contemporaneous public access to it. Application of national broad case law. At issue, here are the second and third prongs of the common law test. Regarding the second prong, the weight of the presumption is low, considering that the news organizations will be able to hear and report on the testimony of Jane, including what is read into evidence, and will receive properly redacted exhibits as they are completed. Thus, the material at issue here is only the physical text of the evidence, not the testimony itself, and thus plays a minor role in the court's Article 3 function. Addressing the third prong, the court contravailing factors have also weighed in favor of non-contemporaneous disclosure. For instance, the court has a strong interest in protecting the privacy interests of witnesses like Jane, who have been granted pseudonym status by the court. That interest is heightened given the nature of the allegations related to Jane, who has also been identified as victim number 2 in the indictment. Pause. Everybody been sitting there saying we only got one victim. So now we on victim number 2. Now we on victim number 2. See Guthrie versus Dershowitz case law. Particularly acute, given that the psychological and emotional well-being of survivors of alleged sexual assaults may be implicated by such a broad disclosure. It is even further heightened given the recent inadvertent exposure of personal identifying information of another pseudonymous witness, and the global media coverage this case has received, which enhances the risk of public disclosure of such details beyond the courtroom. Y'all hit that like button, y'all. Further, with regard on the orderly conduct of the trial and judicial efficiency, the requests the news organizations have made to either publish the exhibits contemporaneously or else delay Jane's testimony by changing the order of witnesses would be impossible to adhere to, given our understanding that Jane is likely to be on the witness stand for multiple days and has a conflict commencing June the 13th, which requires that her testimony conclude before that time, and which the parties have agreed to honor. Nor is it my understanding would a short delay allow for the careful and proper redaction of the volume of exhibits that are at issue. Indeed, such a delay would therefore be inefficient and would threaten the ability of the parties to fully examine Jane. So, skip all that. Accordingly, the court should deny the news organization's request to change the order of his witnesses or otherwise delay the testimony of Jane to allow for a pre-redaction of exhibits to be introduced during Jane's testimony. That comes from Jane's lawyer, right? That comes from Jane's lawyer. Now, let's get to the meat and the potatoes of this whole thing. My question, will Diddy get a mistrial or will he not? And I know y'all sitting back like, Dana, why would you ask that question? Well, you about to see why. Because on yesterday, okay, hey, Galatians. Hey, if y'all like this content, man, y'all go and hit that super chat or that cash app. Y'all go and hit that like button as well. All right. Now, here's the big thing. Will Diddy get a mistrial or not? Why you ask that? Let's talk about it. Let's talk. Hold on. Let's talk about why I asked that. Dear Judge Submarinian, the defense respectfully submits this letter in support of its renewed motion for a mistrial based on prosecutorial misconduct. When the introduction of perjured testimony results in a criminal conviction and the prosecution knew or should have known of the perjury, the conviction must be set aside if there is any reasonable likelihood that the false testimony would have affected the judgment of the jury. Pause. What makes Diddy any different from R. Kelly? If they prosecuted, thank you so much, Galatians, appreciate it. I need 9 more people. But Galatians came through with the 10-piece. If R. Kelly had to get prosecuted from bad acts and bad witnesses and lies, what makes Diddy so different? So, United States versus Wallace case law. Accord, United States versus Walters case law. Moreover, the prosecutor's knowing use of perjured testimony can violate the due process clause, even if it only undermines a witness' credibility. United States versus Cromartie case law. And State versus Argus case law. As the Supreme Court has explained, a lie is a lie, no matter what its subject and if it is in any way relevant to the case. The district attorney has the responsibility and duty to correct what he knows to be false and to elicit the truth. Napi versus Illinois case law. As explained below, in this trial, the government has presented testimony that it knew or should have known was materially false related to its allegation that Mr. Combs dangled Brianna Bongaloin from the balcony of Cassie Ventura's apartment in September 2016. Accordingly, to avoid an unfair conviction in this case, the court should grant a mistrial. Stop there. How do you know that Diddy didn't do it? You wasn't there. I wasn't there. But how do you know that Diddy didn't do it? So it goes on to say the government contends the alleged balcony incident is relevant because it shows Mr. Combs' violence directed not only to Ms. Ventura, but to other people around Ms. Ventura. She is aware of this violence, and because of her awareness, it goes to coercion. The incident, as alleged, is disturbing and powerful evidence, and the government has used it to depict Mr. Combs in an extremely negative light as an angry and dangerous man who terrified Ms. Ventura and her friends. Pause. So what you telling me, defense, is that he didn't do it? Is that what you're telling me, defense, that Mr. Combs didn't do it? So who was that on the video? Who was that blew up Kid Cudi car or tried to blow up Kid Cudi car? I'm just saying. So then it says the prosecutors elicited evidence about this allegation from both Ms. Ventura and Ms. Bongaloin that is demonstrably false in key respects. They then doubled down using this false testimony to obtain a ruling admitting inadmissible hearsay evidence about it as well, all to present a false narrative to the jury. The government started by eliciting testimony from Ms. Ventura about the allegation that cannot be true. Whoa, why can't it be true? Ms. Ventura said she actually saw Mr. Combs holding Ms. Bongolian over the balcony railings. I saw him bring her back over the railing of the balcony and then throw her onto the patio furniture. Yet the prosecutors knew she had not actually seen what she described because they had in their possession a text conversation demonstrating that Ms. Ventura was told about the alleged incident by another unidentified person. CGXC-361-C. Hey, I just found out some crazy shit. I'm just finding out right now. Nonetheless, they allowed Ms. Ventura to continue to insist on cross she had witnessed this incident. See trial paperwork 1069. Question. And you testified that you saw him throw her onto the patio furniture, right? Answer, yep. He brought her back over the balcony and he threw her down. She persisted in this story even after she was confronted by the text messages. Isn't it true that you learned about this incident on the balcony after the fact? I saw what I saw, so I don't know. Huh? Has the government, in your preparation for your testimony in this case, has the government, in your preparation for the testimony in this case, gone over this message with you? Not this one, no. Thus, the government left the jury with the false impression that Ms. Ventura saw Mr. Combs dangle her friend over the balcony and that this made her fearful of him, when in fact, if there was any incident, Ventura merely heard about it afterwards, considerably lessening any probative value as to her state of mind. Next, the government doubled down by presenting perjury testimony from Bongolian intended to corroborate Ventura's false testimony. Bongolian claimed Combs lifted her up and held her feet on the balcony railing, and that this caused injuries to the back of my leg and back and neck pain. Bongolian was very definitive about these injuries, and particularly the bruise on her leg, which as one of the details that stick out in her mind. So I'm gonna ask this question. Do you believe it should be a mistrial so far? Put yes in the chat or put no in the chat. As the government also knows, like other witnesses in the case, Ventura and Bongolian have been in frequent contact at key points and have had many opportunities to collaborate on their stories. And in fact, Bongolian admitted the two friends discussed this incident before and after Ventura filed her lawsuit. Bongolian also has an enormous financial motive to lie because she filed a $10 million lawsuit against Mr. Combs based on this same allegation and will benefit by exaggerating the scope of her injuries to obtain damages. Her account makes no sense and seems to be physically impossible. Mr. Combs is only about 6 feet tall, and even if he's bigger than her, he is not tall enough to have been able to hold a shorter adult by her armpits, so high that her feet would have been on the balcony railing, as Bongolian testified. California law required balcony railings to have a minimum height of 42 inches. Ooh. Where did you go after you left Cassie's apartment? I went to my apartment. What did you do at your apartment? I was shaking a lot. And then I wanted to take a shower because I felt disgusted. And then I look over behind my leg and I see a huge bruise. We'll talk about the bruise in just a moment. Ms. Bongolian, do you remember all the details of the incident that night? No. Do the details that have talked about stick out in your mind? Yes. What, if any, physical injuries did you have as a result of that night? I had that big bruise with like it was like a piercing in the middle of it. And then I had back and neck pain. And the government next introduced photographs of the injuries Ms. Bongolian supposedly sustained at the hands of Mr. Combs, including GX33S-1028. A photo depicting the leg injury taken on September 26, 2016 at 9:45 a.m. Ms. Bongolian testified that she took the photos of her leg injury around the time indicated in the exhibit, that she did so the same day as the incident, and that she got that injury from being thrown onto the balcony furniture. On cross, she confirmed that the balcony incident happened early in the morning, that the photo of the leg bruise was taken later that day, and that the injuries to her back and her leg happened on the same day. The government then introduced photographs of the injuries supposedly sustained at the hands of Mr. Combs during the incident. The government knew, or should have known, this testimony was perjured, and that Ms. Bongolian could not possibly have been injured by Mr. Combs on a Los Angeles balcony in the early morning hours of September 26th, or even the day before that. The government has long known that Mr. Combs was on the East Coast in late September, and specifically at around the time of this alleged incident. The government knew that he had stayed at Trump Hotel in New York City between September 24th through the 29th, 2016. In fact, the government had marked as GX7Y111 the records of this hotel stay, which are now in evidence. And it has had other evidence in its possession for some time showing Mr. Combs' travel schedule and proving that he was on the East Coast when it told that jury he dangled Ms. Bongolian over a balcony in front of Ms. Ventura. I'm gonna ask y'all this question. Do you think Diddy's a monster? Or do you think that he's just being him? That's all I want to know. Just tell me what you think. Crackheads testifying against him. Who believe Clucks now? Well, you can't really say that, Skylife, because when you look at it, he was doing drugs with him, right? So I guess they all one big family. What's more, when the defense began to expose the perjury on cross-examination, the government repeatedly attempted to disrupt the cross with unfounded objections and requests for sidebars. The unfounded claims, such as that proper leading questions when defense counsel was testifying. Then, despite having elicited Ventura's false testimony about having directly witnessed the alleged incident, the government persuaded the court to admit the hearsay text messages with Karam describing what Ventura had found out. from someone else, despite having elicited perjurous testimony from Ventura claiming she saw the alleged conduct. All of this was highly improper and exacerbated the harm caused by subordinating the perjured testimony. Wow. Let's get through this, y'all. It bears emphasis that the use of the perjured testimony regarding the balcony incident is just one example of prosecutorial misconduct. During this trial, the defense previously moved for a mistrial based on the improper line of questioning related to the 2012 destruction of fingerprints provided by Scott Muscati to the LAPD. As the court will recall, the defense argued that the government's motive in eliciting this testimony was to create an unfounded and highly prejudicial inference that Mr. Combs somehow had corruptly arranged for the destruction of the fingerprints. The government claimed that was not the purpose of its questions, and the court denied the motion and instead gave a narrow limiting instruction. Hold on for a second, y'all. Hold on. Woo! I get some drink. My mouth dry. Gotta get some church punch. Get it. Oh my God. Let's get it. Woo. I got my church punch. All that sugar done kicked in. I got it. Oh yeah. Let me see what y'all talking about. All the crackheads, they lying on Rob. Crackheads testifying against him. Who believes Clucks now? Okay. Wow. Heard your testimony. Okay. However, it became apparent shortly thereafter, during the questioning of Mia the very next day, that in fact the government's motive all along must have been to suggest that Mr. Combs had corrupt influence over the LA authorities when it tried to create the impression that he was responsible for the destruction of the fingerprints. Specifically, the government elicited testimony from Mia about 2 incidents in which the LAPD did not issue a ticket for speeding after she was pulled over because the officers found out she worked for Mr. Combs. In one case, Mia got pulled over speeding, name drop, that her boss Mr. Combs, and got him on the phone. After which the officer was saying, like, oh my God, Puff Daddy, I love you. Like, just went into this whole very excited conversation, and then she let me go. The second time, Combs was in the car. And once they saw Puff, they were like, oh, my bad, yeah, and left us alone. The prosecutor took special care to emphasize that these incidents occurred in Los Angeles. What city did these interactions with the police occur in? LA. These incidents in isolation seem like beaming examples of police giving lenient treatment to popular famous people, coupled with the sinister implications of the fingerprint destruction. However, they create a strong implication that the reason Mia, and as the government will surely argue, other alleged victims didn't go to the police was because of Mr. Combs' corrupt influence over the police and the LAPD in particular. In other words, the subsequent questioning of Mia, even if itself permissible, further corroborates that the government's real purpose and its questioning of the fire inspector Lance Jimenez was to improperly suggest that Mr. Combs corruptly caused the destruction of the fingerprints. This constitutes another instance of prosecutorial misconduct. Accordingly, the court should grant a mistrial based on prosecutorial misconduct. Respectfully submitted, Alexandria A.E. Shapiro, Mark Agnifilio, and Anna Estreva. Then you got Brian Steele, the Steele Law Firm, Xavier Donaldson, my guy, and Nicole, the sixth lady of the beast, Westmoreland. I'm just saying, on some real stuff. I'm just saying. What do you think? What do you think? Me? I don't know. I don't think it should be. You know what? This is what I'm gonna do. Call in 404-914-7986. If you want to talk about this Diddy thing, you want your voice to be heard, call in. Because I want to hear from you. I want to hear from you what you think. Because this is crazy. This is crazy. Let me see what y'all saying. Let's see. Skylife said crackheads testifying against him. Who believes Clucks now? Ooh, that's bad, Skylife. That's bad. That's bad, Skylife. Skylife being bad now. Instead of trying to persuade the jail, they should prove what they are changing with is just that. Not all of this extra crap. At this point, passing a bar exam doesn't mean anything. Okay? My ex-in-law worked for the police department. When my daughter was pulled over driving their car, they ran tags and let her go. That's on the department for being starstruck. That part right there. Typo, persuade the jury. The judge always sides with the government prosecutors. You think so? They saying Trump will sign him. You think so? No, I don't. No, I don't think so. It's a cold world, fam. So what do y'all think? Normally Skylife would have jumped up here by now. I guess Skylife don't want to talk. Skylife like, I'm done. I'm just saying. I'm in the middle.